We need to look further at what is motivating the Trump legal argument. It's the same thing over and over again. Let's discuss. I'm Dave Aronberg, former state attorney for Palm Beach County, aka the Florida lawman here on Legal AF. In the case of Mr. Abrego Garcia, the El Salvadoran national who was here legally and who was subject to a court order that said he cannot be deported because he risks being threatened, being attacked, being killed by gang members. And so the Trump administration violated that court order. That court order was from 2019. But what is underlying the Trump administration's arguments here in all these cases is the same thing. And that is the MAGA legal principle that the executive branch dominates over the other two branches of government. And you combine that belief with the once fringed unitary executive theory that's now caught on in legal thought that the president just presides over the entire executive branch. It's a executive branch decision maker of one as opposed to thousands of people in the executive branch. This is the president has the only authority in the executive branch. He dominates, and then you have the executive branch who dominates over the other two branches of government, and you combine that with the Alien Enemies Act of the 18th century, which says that if we're at war or if another country is invading us or threatening to invade us, that the president can do things like deport foreign nationals. But even that act requires due process, and that's where the courts come in. Because for the first time in history, we've seen one branch of government, the legislative branch, arguably the most powerful branch, the branch that's discussed in Article 1 of the Constitution that tells you how powerful it is, and it tells you because our framers gave Congress the power of the purse that it's supposed to be the most powerful branch. But for the first time in history, the legislative branch has decided to emasculate itself, has decided to give all its power to the executive branch. That's where we are. But yet judges have been doing their jobs. They've been stepping up. They've been providing the guardrails. And if you thought that judges would act like the politicians in Congress, well, then you've never been before a federal judge who has lifetime appointment, who has the gavel and wears a black robe, and you have to stand up every time they enter a room. They're not going to give up their power so easily. They're not going to cower in the face of an elected official calling them out. And you're seeing that in these cases. So when the Trump administration goes before these judges and says that, Judge, you have no power here, it's not something that Article 3 judges like to hear. They don't like to hear that, no, you have no authority in your own courtroom. And so they're pushing back and using very stern language, as Judge Zinnes did in the Abrego Garcia case. We're talking about a person who is subject to a 2019 court order that says he cannot be deported because he risks retaliation from gangs back in El Salvador. So we're not even talking about a Venezuelan national. We're talking about someone who was caught up in the deportations, and the Trump administration admitted that that was a mistake. But now they're saying, number one, Judge, you have no power over our decisions and to force us to do anything. And number two, that even if you did, we can't get him back. He's now a resident of the country of El Salvador. But that argument, too, is faulty, because the Secretary of the Department of Homeland Security, Kristi Noem, famously or infamously stood up and said that this notorious El Salvador detention center is a tool in our toolkit. Okay, well, then if they're your tools, you have responsibility over them. And the Judge Zinnes, says, to use another metaphor, you broke it, you own it. Judges are empowered to interpret the law, but enforcement of the law is in the executive branch. So even judges, when they depend on the enforcement of their contempt orders, they go to the U.S. Marshals Service, and the Marshal Service is under the executive branch. So that's when the constitutional crisis really comes, when the judge says you're sanctioned, and then the executive branch says, so what? What are you going to do about it? That hasn't happened yet, but it could. And so we're going to see what happens with Mr. Abrego Garcia. So when the Article 1 folks in Congress say that they're going to emasculate themselves, essentially give up all their power to the executive branch, at least the courts are stepping up. The courts are doing what they're supposed to do. And then there is the U.S. Supreme Court case of Rasul v. Bush. It's important that we discuss that. That's from 2004. Remember, after 9/11, President George W. Bush, he rounded up, through his administration, suspected terrorists around the globe, people who were not in the United States, who were foreign nationals, and then sent them to Gitmo, Guantanamo Bay in Cuba, and said they don't get due process rights. They're not American citizens. They're not on American soil. Yes, it's an American base, but it is not in the United States. And the Supreme Court said otherwise. The Supreme Court there in that opinion said that even suspected terrorists who are foreign nationals and captured abroad are entitled to due process at Gitmo. The Supreme Court said that federal courts have always had power to hear challenges involving executive branch detention that's in wartime and in peace. So that would seem to be pretty powerful precedent here, especially when we're talking about individuals who have not been convicted of a crime, but who are suspected of being members of a gang and then shipped off to a notorious detention center in El Salvador. Call it a prison, whatever you want to call it. It is notorious. And hey, I'm all for it. If they are hardened gang members, let's get them out of the country. But you better get it right. And due process ensures that we get it right, because if you ship someone off who's just an innocent person in this country who has no ties to MS-13, then that would be a tragedy to put him in that hellhole in El Salvador. That's why judges are important. It's not just the word of the president. That's checks and balances. That's what protects us against tyranny. That's what protects us against mistakes that can destroy lives. In this Rasul v. Bush opinion, the Supreme Court said that Congress has granted federal district courts within their respective jurisdictions the authority to hear applications for habeas corpus by any person who claims to be held in custody in violation of the Constitution or laws or treaties of the United States. So what they're saying here is that, yeah, you're entitled to due process. If you think you're wrongfully detained, if you think you're wrongfully deported, the courthouse doors are not closed to you. They say that habeas corpus is a writ antecedent to statute, throwing its root deep into the genius of our common law. So they're saying that this has been around from the beginning of our country. This is part of the common law, not just statute. This is something that is ingrained in our legal jurisprudence, that you get the ability to see a judge. And this claim that judges have no juice, yeah, as I said, judges don't like that on both sides of the aisle. Consistent with the historic purpose of the writ, this court has recognized the federal court's power to review applications for habeas relief in a wide variety of cases involving executive detention in wartime as well as in times of peace. The court has, for example, entertained the habeas petitions of an American citizen who plotted an attack on military installations during the Civil War, and of admitted enemy aliens convicted of war crimes during a declared war and held in the United States and its insular possessions. And then the court concluded that in the end, the answer to the question presented is clear. Petitioners contend that they are being held in federal custody in violation of the laws of the United States. No party questions the district court's jurisdiction over petitioners' custodians. It's so interesting because now they are questioning the district court's jurisdiction over these individuals. By its terms, requires nothing more. We therefore hold that Section 2241 confers on the district court jurisdiction to hear petitioners' habeas corpus challenges to the legality of their detention at the Guantanamo Bay Naval Base. So there you have it. In the case of the Aliens Enemies Act, there is no oversight. There is no guardrail. That's antithetical to our whole system of justice, our Constitution. We'll keep following it here on Legal AF. I'm Dave Aronberg, aka the Florida Lawman. If you like this video, please like, subscribe, share with a friend, and leave a comment below. Love reading your comments, even when you disagree with me. Thanks for your support, and I'll see you next time.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.